Denied a promotion, dismissed in court, but not done yet. Tommy Ho faced down the very supervisors he named in discrimination complaints. Tune in for a federal employment showdown that's far from over. Hi, I'm Mira from Courtroom 5, and this is Who Wrote That Up For You, the show where we follow everyday people battling in civil court without a lawyer. Today we're diving into Tommy Ho versus the Attorney General, a case that shows how persistence and careful fact-gathering can turn an apparent loss into a second chance at justice. Tommy Ho is an Asian American who's worked for the federal government since 1999. By 2015, he was a GS-13 criminal investigator with the Bureau of Alcohol, Tobacco, Firearms, and Explosives in Washington, D.C. But Tommy believed he was being discriminated against. In 2015, he filed his first equal employment opportunity complaint, claiming ATF racially discriminated against him by forcing him into an unwanted transfer. Then, in 2017 and 2018, Tommy applied for 3 different GS-14 promotions. That's a significant step up in federal service. He didn't get any of them. So, he filed 2 more EEO complaints, this time alleging retaliation. Here's where it gets interesting. In those complaints, Tommy specifically named 3 supervisors as responsible management officials: James McDermott, Kevin O'Keefe, and Edward Kropke. These weren't random accusations. These officials had to answer interrogatories and sit for depositions as part of Tommy's complaints. Fast forward to June 2019. Tommy sees another opportunity, a GS-14 program manager position in something called the Internet Investigation Center. This wasn't just any job. Tommy had experience in internet-based criminal investigations, and his supervisor O'Keefe had given him positive performance reviews and acknowledged Tommy's solid skills and investigative knowledge. The position was initially advertised only to people already at the GS-14 level, but nobody applied. Because there was a need to fill it, they opened it to GS-13 applicants like Tommy. On August 8th, ATF Human Resources told Tommy he was among the best qualified for the position. The interview panel consisted of 4 people, including 2 familiar names, O'Keefe and Kropke, the same supervisors Tommy had complained about. O'Keefe was the primary member of the panel. During the interview on August 28th, O'Keefe later admitted that Tommy knocked it out of the park on some questions, suggesting he received perfect scores. But, according to O'Keefe, at some point during the selection process, McDermott, the 3rd supervisor Tommy had complained about, intervened and suggested to the panel they could choose not to make a selection. The next day, August 29th, Tommy was told nobody was selected for the position. Tommy asked O'Keefe what happened. O'Keefe said all 4 applicants were qualified, but 2 had outside factors that disqualified them. As for Tommy and the remaining applicant, O'Keefe claimed they did not answer the interview questions well enough. Despite admitting Tommy had knocked some questions out of the park, here's the kicker. The other remaining applicant who wasn't chosen had also been engaged in litigation with ATF since 2014. 2 qualified candidates with histories of filing complaints against the agency, both rejected for the same subjective reason. Tommy filed another administrative complaint alleging retaliation. A TF dismissed it. The Equal Employment Opportunity Commission upheld that dismissal. So Tommy, representing himself, took his case to federal court, claiming unlawful retaliation under Title VII. The government moved to dismiss, arguing Tommy hadn't adequately connected his protected activity to his non-selection. The district court agreed. The judge said there was too much time, 10 months, between Tommy's last EEO complaint and his non-selection to suggest retaliation. Case dismissed. But Tommy wasn't done. He appealed to the D.C. Circuit Court of Appeals, still representing himself. Here's where Tommy's meticulous fact-gathering paid off. The appeals court looked at the same facts but saw a very different picture. They said, you can't just look at timing in isolation. You have to consider the whole story. First, the officials making the hiring decision weren't just aware of Tommy's complaints. They were the subjects of those complaints. That's not just knowledge, that's personal involvement. The court noted that supervisors are more likely to retaliate against employees who complained about them specifically, rather than employees who complained about others. Second, Tommy was clearly qualified. A TF Human Resources said so. O'Keefe said so. Tommy had relevant experience and he performed well in the interview. Third, ATF really needed to fill this position. They'd expanded the candidate pool specifically because of this need. Yet after finding qualified candidates, they suddenly decided not to hire anyone. Fourth, the reason given was entirely subjective. interview performance wasn't good enough, despite acknowledging Tommy excelled on some questions. The appeals court expressed concern about how easily subjective criteria can mask or camouflage discrimination. The appeals court reversed the district court's dismissal. They said that when you look at all these facts together, rather than in isolation, Tommy had alleged enough to suggest his protected activity was a but-for cause of his non-selection. This case offers several useful takeaways. 1. Document everything. Tommy didn't just file complaints, he created a paper trail. He kept track of who did what when they did it and how it connected to his case. He named names, he saved emails. He noted performance reviews, interview comments, and sudden changes in process. That level of detail became his most powerful evidence. If you're representing yourself, this is one of the smartest moves you can make. 2. Context matters. Timing alone might not prove retaliation, but timing plus specific facts about the decision makers as your qualifications and the employer's stated needs can paint a compelling picture. In Tommy Ho's case, 10 months had passed between his last EO complaint and the promotion denial, normally too long to suggest retaliation, but context changed everything. The people who denied him the promotion weren't just any supervisors, they were the exact ones named in his complaints. He had stellar qualifications, got high marks in the interview, and the agency had an urgent need to fill the position. And yet, they hired no one. Looking at those facts together, not in isolation, the court saw a pattern that suggested retaliation was at play. For pro se litigants, this means one thing: tell the whole story, not just the timeline. 3. Scrutinize subjective excuses. When employers offer vague reasons for adverse actions, like "you didn't interview well" or "poor fit," it's often a red flag, especially in retaliation cases. Courts are wary of such subjective justifications, which can mask discrimination or payback. If you file complaints and then face unclear feedback or shifting standards, document everything. Don't accept "we went in a different direction" as a final answer. Whether you're fighting discrimination, retaliation, or any other workplace wrong, remember Tommy Ho's approach. Document everything, look at the big picture, and don't give up when someone tells you your story doesn't add up. Sometimes it takes an appeals court to see what a trial court missed. This has been Who Wrote That Up For You? Until next time, keep fighting for what's right.